out deep in my soul. In the midst of the darkness, a signal shines bright. WUCC 99.9, bringing hope to the night. Voices rising, uniting in grace. A church without walls, you can find your place. Your place. 24 hours, the truth comes alive. With every story shared, you can learn to thrive. Spreading words of faith into the air, guiding our spirits, showing we care. Listen daily, let the message ignite. It's WUCC, we walk in the light, where you get your meat with your daily bread. Heartfelt words spoken, putting light on the way ahead. Together we rise, hearts beating as one, in the voice of truth. Our battles are won. That echo, calming our fears. Hands of the faithful, we reach for the sky. Voices of hope, painting colors so bright. With every heart touched, we're changing the night. Listen daily, let the message ignite. At WUCC, we walk in the light, where you get your meat with your daily bread. Heartfelt words spoken, leading the way ahead. Together we rise, hearts beating as one, in the voice of truth. Our battles are won. So turn on the radio, let it play through the day. WUCC 99.9, guiding our way. In this church without walls, we're never alone. With each voice united, we're making it home. Listen daily, let the Spirit unfold, in the voice of truth. Our journey is gold.
It's the Daily Steward Show with Bill Robinson. What does God's Word say about stewardship? Being a good steward. Working out your salvation.
Sharing the gospel.
Casting out demons. Healing the sick. Fulfilling your role as husband or wife. Attending church. Work.
Handling money.
Gifts and talents. Managing our time. Yeah, there's a lot to say.
Tune in Wednesdays at 10 here on WUCC 99.
Well, good morning. It's another great day in the state of South Carolina. We're here in New Ellington, South Carolina, live. I'm Bill Robinson, the host of the Daily Stewart Show, and I'm here with the great pastor Bill George from University Parkway Church of God.
Hello, everybody. You're going to have a good show today.
Yeah,
Good show today.
Yeah, we're really excited about it. And thank you, Pastor, for being here and all you do. Conquering with Christ LLC is a Christian broadcasting company. On the web, you can locate WUCC 99.9 at cwchrist.com. Again, that's cwchrist.com. Located on the website are contact numbers and how to support the ministry of WUCC 99.9 FM. If you'd like to contact me directly, you can at bill@thedailystewart.com. That's bill@thedailystewart.com. The opinions today are our own. They don't necessarily represent that of the station or the station owner. And we're going to talk about, again, just what is a steward. It's someone who's appointed to manage something. So keep that in mind. And as Christians, we have a responsibility to steward what God has given us. Stewardship is critical to our Christian walk and witness. So last show, we talked about inheritance, and we covered a spiritual inheritance, and we covered also a physical inheritance. And we're going to continue that discussion today. So in advance, I want to mention this disclaimer because we are not attorneys. So the content of this show is for general information purposes only and does not constitute the practice of law or legal advice. The content presented today does not guarantee compliance with any laws, regulations, or standards. WUCC and the participants of the Daily Stewart Show make no warranties, express or implied, as to the accuracy or completeness of the content of today's show. Listeners should consult with their own advisors. This station and this show are not liable for any errors or omissions. Okay, I think we got that behind us, Pastor Bill.
Amen.
So let's briefly review last week's topic of stewarding the next generation, which has been our theme, and talk about the passing of a physical inheritance to your heirs. We call this estate planning. So, Pastor Bill, would you mind reading last week's scriptures from the King James Version?
Okie dokie. Let me get right here.
Yep.
All right. Excuse me. Proverbs 21:20. There is a treasure to be desired and oil in the dwelling of the wise, but a foolish man spendeth it up. Excuse me. Proverbs 13:22. A good man leaveth an inheritance to his children's children. Proverbs 19:14 says, a house and riches are the inheritance of fathers. 1 Timothy chapter 5:8 says, but if any provide not for his own, and especially for those of his house, he hath denied the faith and is worse than an infidel.
Well, thank you, Pastor Bill. So that's some good scripture, some good Bible verses to keep in mind here. Now let's review documents that are typically prepared by an attorney. And your attorney will usually provide these as part of your estate plan. So the first thing would be a last will and testament. And that can be as easy as a one-page document. I know in the case of my parents, it was just a simple one-pager. It said, I'll leave everything to my spouse and children if my spouse doesn't survive me. And likewise with my mom's will, it said the same thing. So those are very easy ones to have. But a last will and testament can be very complex too. I've seen some that have 20, 30 pages, and included in the will is actually the provisions for setting up a trust. So that can be something that you would talk to your attorney about and see what fits your circumstances. And then there's a durable power of attorney. Usually these are kind of dormant documents that may not spring into life until the death of one of the parties that is granting the power of attorney. But you can have a durable power of attorney in place that is active and enforceable while you're living. If you do that, you just need to make sure that whoever you name as the power of attorney is not going to abuse that right, that you trust them. And then there's a healthcare power of attorney and living will. And these are becoming more and more important. So if you don't have this, if you've done estate planning in the past, you may want to go back to your attorney or see if there's a way you can get one of these executed for you. Because when you're in the hospital, and let's say you're out, totally out. I mean, you're on life support, or you're in a coma. Somebody has to make those healthcare decisions. And if you don't have this, the hospital will be the one making the healthcare decisions. I don't know if you see that when you've ever gone to a hospital, you have to sign a bunch of documents. Do you ever remember doing that, Pastor Bill?
Oh, yeah. Lots of documents. Before they even see you, they want it all signed.
Yeah, so they're asking you to sign things that say, in essence, we can do whatever we want to in the treatment and providing care for you based on our opinion and medical training. So that gives them wide latitude to do a lot of things, and you may not want certain things. A lot of hospitals now will automatically start vaccinating you with various shots if you don't have some way to stop them or say you don't want those. So that's just an example. They may do a blood transfusion, and maybe you don't want a blood transfusion. Again, these are things that you have to think about. And then you want a HIPAA release document in conjunction with that, because you have to have the ability to get the medical information released to you. So that document would name individuals probably in your family that could receive up-to-date medical information from the doctors, the hospitals, anyone that's treating you. And then you want a patient advocacy document. And this is important too, because even if you don't have the healthcare power of attorney effective, because maybe you're alert and able to make decisions, there are times when you're in the hospital. I know when I was in the hospital for a heart attack in AFib condition, there were times that I was sleeping or under some sedation, and my wife was there. So she was my advocate to make sure there weren't any kind of interesting things going on with me that I didn't know about. And this is becoming a bigger and bigger thing too, because we've even seen in some of our friends where the hospital has kicked them out of the hospital or tried to kick them out because they argued with the medical staff about the treatment. And I know in one case there was a friend of ours that actually had legal grounds brought against them by the hospital, and they had to fight that. So you want to have that advocacy document in place so that you can properly represent whoever's in the hospital if it's you.
A real quick question for you, Bill. I don't know if you know the answer for it or not, but if you say you signed a donor thing on your driver's license and you have a patient advocacy, do they overwrite that?
No, I mean, if you've got that signed on your driver's license, that's basically your legal consent to have that, and an advocate couldn't override that, but they could, make sure that you're not donating organs before you need to, which I hate to say that, but you never know nowadays. And then also they may typically look at a trust and whether you need a trust. And again, that's going to be very unique to your circumstances. So in addition to those formal legal documents, it's important to think about some specific instructions that you would give your executor or representative or other individuals like your surviving spouse or relatives, notes or instructions to follow. So probably the first thing, if I were to die today, would be who is my wife going to contact? So I would hope initially she would probably call you, Pastor George, and let you know. So it might be a pastor, but also we have a what I call a death book, and in that 3-ring binder, there's instructions of what the attorney, who the attorney was that drafted the will, and phone number so that she can contact that person if need be. If there's a CPA involved, the contact numbers for that. Maybe there's an insurance broker or insurance policy, contact numbers for that. Maybe there's an investment advisor, and there should be contact numbers for that person. And really any other person that would make sense to contact. For instance, perhaps there's a funeral home that's already been designated, and those contact numbers are helpful too. And then you need to make a list now, before you die, of personal property and indicate who should inherit each item. And that's really to prevent squabbles among your relatives. I don't know if you've ever seen any of those squabbles, Pastor Bill.
Yeah, I've seen many of those squabbles.
Yeah, and it, again, what you're trying to do is make it as easy as possible for your heirs, and so that there's no disagreements or hard feelings. So some of those items might include a vehicle, furniture, collectibles, heirlooms, jewelry, musical instruments, sports equipment, and other personal property that may have value. Instead of saying in your will, just put it out in the front yard and everybody wrestle to see who wins to get it. You're basically listing it out line by line and saying, okay, I want so-and-so to have this watch. I want so-and-so to have my iPad. I want so-and-so to have my desk. I want so-and-so to have my sports equipment, etc. And that way everybody knows what my intent was. And if I were to receive sports equipment from as a beneficiary, and maybe I didn't want it, then I could decide to give it to somebody else, and that's a relative. But at least there's a way for you as the person planning your estate to make sure that there's maybe not squabbles there. Now, I want you to note that in South Carolina, I believe on vehicles, boats, trailers, etc., you can do a transfer on death and the registration. So that may be something you want to look into, again, just to make those types of titles easy to transfer and go to the right people. And then what are the details of your burial? Will there be a traditional burial or a cremation? What funeral home will handle these arrangements? Open or closed casket? Is there burial insurance? You know what we call the burial insurance, don't you? It's layaway. I'm sorry. I'm sorry, I couldn't help that.
Yeah. That was good.
And then make sure you write out your wishes for your funeral services. Who will officiate the funeral? Who's going to speak? Who's going to sing song? Who's going to read scriptures? Or do you have scriptures that you won't read? Who to appoint as pallbearers if you have a traditional burial? Pastor Bill, I just want to say you probably over the years have officiated many funerals. Mm-hmm. I don't know if you've ever gotten to one where somebody just doesn't know what the service is going to look like.
It's very sad when they have no plans whatsoever on it. And there are advantages that you're talking about of knowing these things, because I don't know if you've ever heard of this, Brother Bill, but there was one guy that had a funeral, and he used a funeral director that they had the service at the church, and the funeral director used all the someone else's funeral home, and it ended up cutting the price down like in half because he was using their stuff at an off time so he could do it for less money, and then they did the funeral at the church, and it cost them like half. I had never heard that before.
Mm-hmm.
But going along with what you're talking about, having a preparation like you're talking about, in all these funeral arrangements, because what's going to happen if you don't, they're going to get Bubba that you can't stand be carrying you to your hole,
Exactly. And really, you don't want the burden on your heirs to have to try to figure that out.
Yeah.
They're going to be grieving. They're not going to be maybe thinking clearly or thinking about these things. Easy to overlook. You're trying to give them a game plan, so that it's easy for them to follow.
And some people might think, well, that's kind of morbid. Excuse me. But as a sheriff's chaplain, one of the first things we do when we go on a death notification is we would say, who do we need to contact? And the reason we do that is not to be mean, but it's to almost kind of snap the person into, okay, this has happened now. Let's get back to reality, and take them off of that initial shock of going way deep into this panic. They've lost somebody. Who do we need to call? Well, I need to call his mom. I need to, and then they start thinking, and they're coming back to reality because they're thinking about what's got to be done. Yeah.
No, that's good. And then, nowadays too, we have websites and we have passwords for bank accounts and social media, for mobile phones, computers, etc. And, there probably needs to be a password list somewhere. Don't put it on your computer where everybody can see it. You want to keep those private, but put them in a place where maybe someone can locate it easily. And again, the way I've set this up is we've got a 3-ring binder. We just call it the death book, and it's got a lot of instructions in it and a lot of information. And then consider whether you need to write letters to maybe your children or other relatives upon your death. I don't know. That's something new. I'm aware of. I don't know if you have ever seen that.
With a loved one writes a letter to their family.
Yeah.
One of the most beautiful, and I hope you don't mind, one of the most beautiful funeral service I ever seen was Steve Hall's wife passed away, and she had written a letter to him and all the grandkids and stuff, and they read it at the funeral, and it was just really beautiful.
Yeah.
And it was something that she said, not someone said about her saying this.
Right.
This is what she said.
Yeah. No, I think that can be very important. So I'm going to pivot now to some topics that are going to expand on last week's show. And I want to talk about probate because this term is something of a mystery for a lot of people. What does it mean when you go to probate? So probate is just a judicial proceeding to determine if a will is genuine and proper and to monitor the distribution of the estate. And in South Carolina, probate court is a special court that deals with the process of probating a will. It certifies the will, and also it may oversee the distribution of assets if persons die without a will or what's called intestate. So in South Carolina, probate court is established in each of the counties. And at the county level of government, it's not a state level court, but each county administers wills and estates through their probate court locally, but they use a unified justice system of the state so that they're all using the same rules. And that makes sense if you think about it. You wouldn't want to, have a county in upstate South Carolina use different rules than the county that we live in. And each county's probate judge is a popularly elected. They have a 4-year term, and they have jurisdiction over both marriage licenses, estates of deceased persons, guardianships of incompetents, conservatorships of minors and estates of minors, minor settlements under $25,000, involuntary commitments to mental institution or chemical dependent units, and they also have exclusive jurisdictions over trust and concurrent jurisdiction with the circuit courts over powers of attorney. So they actually do quite a bit in addition to administration of estates. So if you go on the Aiken County Probate Court website, it states if the decedent has a last will and testament and the estate is going through probate, the executor must bring the following to begin the probate process.
Bill, can you explain what a decedent is?
Yeah, so a decedent is the person who died. So in the case of the will, they're the person who wrote out the will.
Okay.
Thank you for that. So the first step is a copy of a photo ID for the applicant. So who is the applicant if you have a will? Well, the applicant's going to be the executor named in the will. So that person would have their photo ID to prove that that's who they are, and being named in the will, and they would take it to the court. And then they'd bring the last will and testament of the decedent. And this is going to be the original. And I noticed they put the original in all caps on the website. And they don't want, some states will accept a copy or a scanned document, but in South Carolina, they want the original. So that means you have to have the actual will signed and notarized, and it's got to have, the original signatures. It's got, you can't just bring a scanned or a copy of the will.
Is it like a marriage license where they put like that seal that's imprinted into it?
Yes, exactly. And usually your attorney will have you sign in blue ink too, to show that it is an original. And then they want the death certificate. So here's the thing on the death certificate, just to note. A lot of people forget about this, but then they'll get around to doing it. But the death certificate could take 10 to 15 days to get through the mail. So you're definitely going to want to start this process fairly soon after the death of the person that you're executor for the estate of. And then there's a $65 fee for running notice to creditors. Now, this is interesting because the probate court is trying to make sure that everybody knows this person has died that may have been involved with some kind of debt with the individual. So they'll, I don't know if they do this now on the internet, but most courts used to have, and they may still have, kind of a paper that they post this in, and the creditors would then look and say, oh, Bill Robinson died, so he owes me $10,000, so I need to put a notice into the probate court that I have a claim against the estate. So that'll happen. So just because you die doesn't mean that your debts are released. They are still, as long as a debtor files a claim, they're going to be paid out of the estate But if the debtor doesn't file a claim and the executor has no knowledge of that debt, then that debt will expire and will not be collectible. And then the deeds to all real estate have to be brought to the court. And then the addresses and years of birth of all persons listed in the will, and these are called the testate heirs, or ones that are listed in the will. And then any spouse and or children not mentioned in the will. So those would be intestate heirs. Now, you might say, well, how would that happen? Well, if there's multiple marriages, there may be the will specifies a spouse that's current and children that were biological, maybe not the stepchildren, but the probate is going to make you list everybody that that you had a relationship with, and children that are not mentioned in the will. And then the personal representative has to be a resident of South Carolina. Now, this is kind of interesting, because if they're not, you have to have at least someone designated in South Carolina to receive notices or have processes served on them, or papers by the court served on them. So if, for instance, we're a border community, so say my executor, because let's say I have a brother that lives in Augusta, Georgia, that I want to be executor. Well, I can name him executor, but then I would have to, when he goes to the court, he would have to have someone living in South Carolina to be able to receive papers from the court. So that's kind of an interesting thing to note. Now, if the decedent did not have a last will and testament, the following documents are required to begin the probate process. And again, we're going to start out with a copy of the photo ID for the applicant. Now, who's the applicant now? There's no will. So, do you know who that might be, Pastor George?
I guess like any member of the family that wanted to do it, I guess.
Well, in the state of South Carolina, there's in the Code of Laws, it's Title 62. There's quite a list of people that could serve, but the surviving spouse gets to override if there's a surviving spouse. They're the primary. So, but if it's a number of other people and there's no surviving spouse, it might be somebody that has the family's approval to move forward. So they're going to come forward with an ID, and then they're going to have a death certificate and all the deeds to all real estate. But here's the catch now. If there's more than one heir, unless you have priority, such as the surviving spouse, you need to have renunciation of right to administration forms signed by the other heirs, allowing you to be the personal representative of the estate. So I don't know if you remember that last example, last show about the 16 individuals related to each other that had, there was no will, and the person died, and they all had a claim to some real estate. Well, those 16 people had to agree who was going to represent the whole group in front of the probate judge. And so in order to do that, once they agreed, they had to sign away their rights to say that they approve of that person representing the estate versus them. So that's going to be quite a process to get all those forms signed.
And what if they just completely refuse to do that?
Yeah, and so if somebody refuses, then what would happen is the court would look essentially to appoint somebody, and that process could take quite a while. And this is why, you want to have a will, because, you're talking about things that take time here that are unnecessary if you have a will. And then there's also that same $65 fee for the notice to the creditors. And then addresses and years of birth of all the interested parties, so that's spouse, children, and all the other heirs. And then you need to furnish the probate court. Now this is interesting because you don't have this with a will, but a fiduciary bond, and that's based on the value of the decedent's personal property, which is usually going to be an estimate. Now, the judge can, or the court can, waive that bond, but the reason they have that bond is because since there was no executor, no will, if there was money that is misappropriated, the other heirs have a bond to lay claim to in case, like, say there was $100,000 in cash in the house and that was spent by the person that was an heir that was thinking that it was all theirs, they weren't going to share it, that bond would cover that misappropriation.
And that's not something you get through like a bail bonds place, is it?
No, I think you would go to an insurance company. Probably the probate court would have suggestions, as most courts do, to go. But I know that you could probably go to most insurance companies and have that bond arranged. And you're going to have to work that out with an insurance company. So that's an additional cost, again, if you don't have a will. And then if your personal representative appointed by the court does not live in South Carolina, you've got to furnish the court with somebody that does live in South Carolina and a residence here so they can serve papers on that person. And the papers the court might serve on the personal representative would be a claim from a debtor or creditor. So you might get a paper served saying, hey, on this estate, there's a creditor that the court has certified the debt and you owe X dollars. So before you can totally settle the estate and close it out, you've got to pay that creditor off. And then for estates that are under $45,000, again, you've got to have a copy of the photo ID for the applicant, so whoever the personal representative is, and you must wait at least 30 days from the date of death to come to the probate court. So I'm not really sure why that's there. I was trying to figure that out and looking at the code, but maybe it's to make sure there's enough assets to meet that 45,000, that they're not going over that amount. And then you have to have a death certificate. You got to have a paid funeral bill. You got a filing fee that's based on a sliding scale on the amount of assets. And then you will need to furnish the court with copies of bank documents and the balances, any amounts of insurance. Again, so they're trying to decide whether you meet that $45,000 or not. And then if you are a decedent, again, that you've died and you have no assets, the court still wants to have a copy of your will, and that is if you have a will, and there's a filing fee of $10. So a couple notes here. The last will and testament must, and this is an interesting term they use, because must means you have to. If they said may, that would be a different interpretation. It says must be delivered to the probate court within 30 days of the decedent's death, along with the copy of the death certificate. The court appoints a personal representative, so that's usually going to be the executor if you have a will, who must be issued letters of testamentary or letters of administration to gain legal authority to manage the estate. So this is when the actual estate administration begins, is when those letters are issued to the personal representative, giving them authority to manage the estate. And an inventory and appraisement must be filed within 90 days of appointment. So once you've been appointed, you've got to inventory the estate. And I want to point something out here. There was a estate that happened. There was a death of an individual, and there was cash that the surviving spouse knew was kept in the home. And the attorney for the that was handling the estate and going before probate sent someone to inventory everything in the house. And the surviving spouse did not accompany that person through the house. And they never could figure out where cash, and they think it was a pretty sizable sum in the tens of thousands, went. It just disappeared. And I would say if somebody comes to inventory the property of a loved one, you probably need to accompany them, especially if you think there's cash or jewelry or coins in the home, because again, you don't know that person, if they're the only one there inventory and there's no oversight, you don't know if they could pocket something and take something that was valuable, and you would never know that happened. So just a little tip there. And in terms of probate, there's an informal one. It can be an unsupervised formal or a supervised formal administration of the estate. And that's going to depend on the value of the estate and whether there are disputes or complexity of assets, or maybe there's a asset that requires specific court approval for the distribution. So something to note here is the titling of your assets. So I've always used to think about this early in my career. How do I want to title my assets? Well, if you title them a certain way, unless the will overrides it, that's how the asset's going to flow. So, the title that we normally think about when we're married is joint title with right of survivorship, right?
Right, yeah.
So you probably did a lot of bank accounts when you opened them at the bank with that kind of title on them, didn't you?
Right.
And so what that does is it skips through the administration process, and that goes directly to whoever the survivor is. So that's a good thing to have in terms of designation. And then you can have a paid on death account title, and that's could be someone other than the spouse. So you might have a bank account that's paid to a child on death, or a brother or sister. So that's a couple ways that you can title things.
So just for an example now, if a person has like a mother living with them, she has her money in the bank and stuff. They don't really charge her any rent or anything like that. Her stuff's at the house and that. Does that just kind of go into the, to that family that's there? Do they have to have a will and all that stuff and go through their house and separate what was mom's and what's not mom's? Or
yeah, they should still have a will for mom that either takes that personal property and designates it back to the family that she's living with, or if there's heirlooms that she specifically wants to give to someone else, that's stated in the will, but that still should be in a will.
Oh, well, one more question. Like,
or it can be a specific bequest if it's not in the will. So she could just write that out on a sheet of paper, sign it and date it and have it witnessed and say, I leave all my personal property to so-and-so.
So, like, if as a brother, and that has a sister that's taking care of my mom, can I just write something to my sister and say, I bequeath to you anything that mom owned. I want none of it. Would that be acceptable? Or
so what you're saying is you would surrender your rights.
Yeah, I was just surrender everything to my sister. Because she's the one taking care of her and stuff.
Right. You could actually, you don't have to do that ahead of time. You can actually do that at the time of death. If there were things that went to you that you wanted to just stay with your sister, but if you want to do that ahead of time, that's fine. It would be better if the mother would go ahead and state that on a sheet of paper and just say, hey, everything is going to go to blank because Bill has agreed, and you could write something out that he does not want any of that property.
The reason I'm asking this is because everything you've said, I see a lot of people that would just say, I'm not doing all that stuff. I'm just taking what was here and just going to use whatever, mom had a car. I'm just going to use the car. Is there like penalties, for not doing this stuff?
Yeah, I think the issue becomes in probate, if there's personal property involved and it hadn't been specifically bequested to a certain heir, the judge will either say, well, the relatives need to divide that up, or the relatives would then say to the probate court, okay, here's how we divided it. And then the judge would say, okay, that's fine. But that's going to be a process that the court's going to have to approve, at least in some form or fashion, in order to move forward in the estate. So it's better to have some kind of specific bequest in writing. And again, those can be outside of the will. They just need to be signed and dated and witnessed. So mom needs to sign and date that, and then a witness. But if it goes through probate and there's been none of that pre-planning, then, the family, the heirs need to get together and submit to the judge, this is how we're going to split this up, and we've all agreed. Because what the judge is looking for is the way to administer the estate fairly and apportion the assets fairly, and to make sure there's no disputes. So if there's no clear direction given, the judge is going to be either looking for a way to do that himself or herself, or the heirs are going to have to submit a plan and say, this is how we want it done. And I think in most cases, I know, let's say I'll use a personal example. In my mom's case, when she passed away, there was a house and there was a ton of, or actually when my dad passed away, rather, there was a house and a ton of personal property just, there. And, we lived in Atlanta. We drove up and, I think we lived in Chattanooga, actually. We drove up to North Carolina, and my wife and I went through all the personal property and told my sisters, hey, if y'all want to come and choose what you want, that's great. But after about 3 weekends of going through stuff and taking stuff to thrift shops and throwing stuff away, we finally just said, hey, if you don't come pick it up today, it's all going to Goodwill. And they had a lot of, this is something about estate planning too. When you get older, as my wife and I have gotten older, and we've kind of gone through a couple moves now. What has forced us to do is to get rid of a lot of junk that our children wouldn't have to go through and figure out whether they want to keep it or send it to the trash heap or the Goodwill or whatever. And I think that's an important step. But having gone through all that, it was kind of our agreement as to what we were going to do with different things. And then for the house, we had to go through probate for that and sold it. And then those assets went to my mom. So I was helping her as executor of the estate to try to help her manage through all that.
It sounds like such a big task.
Yeah, it can be. It's quite a bit of work working through that. Even if it's a simple, my parents were very simple people and didn't have a lot of assets other than their house. But it was a very simple process to go through, but it takes a lot of time. And then I want to talk briefly about a revocable trust, because I know a lot of people may have questions about that. And a revocable trust simply bypasses probate, because the assets go to a trust that then becomes irrevocable, and then all the assets get distributed to the beneficiaries at the date of death or sometime post date of death, depending on how the trust is set up. And just to give you an example of that, I was the executor for Gigi's mother's estate, and we had set up a revocable trust for various purposes for her. And what happened was, when she did die, we didn't have to do any kind of major probate. Of course, we had an attorney that had filed the will in the county that she lived, as well as the trust agreement. And I also had a durable power of attorney, so I had the ability to manage that and manage the trust as well when she died. And so it was as simple as at the funeral, me writing some checks to the individual beneficiaries, which were her 5 children, and then also making sure her IRA was split 5 ways. So I was able to do all that at the funeral with the 5 children. I went through everything with them, what her estate was, what the anticipated debts were that needed to be paid off, the final tax returns, etc. And it was really a smooth process, because we really didn't have to involve the court with anything. So if there's a certain circumstance where you need a revocable trust, that is expensive to set up, but it can be very worthwhile. So I want to go into where these documents should be kept, because I get asked this question a lot too as well. Where do I store my records, my trust, and if I have a trust, or my documents, my estate planning documents. So the best places to store that would be really up to you, but it's going to be a balance between security and access. So you should choose a location that protects your documents, obviously, from fire, flood, or theft, while ensuring that your executor or the trustee in the case of a trust can easily locate and access them upon your death. So I'll say this, many attorneys that draft wills or set up revocable trusts with wills will have copies of all that in their office, and they'll have a second set, of signed documents that, they'll retain and you'll retain a copy. The only issue with that is if the attorney retires or dies suddenly or goes out of business, where are their records going? And sometimes their records get transferred to a new firm because another firm will take over when they retire. But sometimes the records just kind of go away. I had one situation in Chattanooga when I was working with in the estate and trust area where the will was drafted by an attorney. The person that was the beneficiary couldn't locate the original. We tried to find the attorney, but the attorney had died and no one knew where any of the records were. So again, if you're dependent on the attorney, just keep up with the attorney. Make sure that, they're still around and able to have those documents. Make sure you ask, well, what's the plan when you retire? Or if you die, where do those documents go? And then a home safe can be beneficial as well, but you have to make sure the home safe is fireproof, flood-proof. And then a lot of people say this, Pastor Bill, will say, I'll just stick all my stuff in a safety deposit box. Well, you know what a bank is like with those. So if you open a safety deposit box and it's in your name and I'm the executor, can I have access to that?
You'll have to bring the documentation and everything that, and then if you have tellers or whoever's opening the thing that doesn't know proper procedure on it, you'll be at the bank for a while. Or if it's a weekend, you might be up a creek.
Yeah, exactly.
And I say that not just for papers, but I've noticed, I knew one lady that was going to India for a wedding, and she had all her Indian gold in the safety deposit box. And she came by on a Saturday, and the bank was closed. And so the next time I saw her, she was saying, I couldn't use any of my jewelry because it was all locked up in the bank.
Yeah, so that's a safe place to store valuables and documents, but like you said, access is difficult sometimes. And most banks, when someone dies, will freeze all their assets, including the safety deposit box. And sometimes it may even take a court order to get access to it. So one suggestion is you could have an executor named on the box, or as long as they're trusted, or it could be jointly. If you're married or you have a relative that's close, you could jointly have each other on the account, and that way you could each have the key and the ability to get in and out of the box. You could scan and upload digital copies, but again, state of South Carolina wants the originals. But if I don't know if and I don't know if there's case law on this, but I don't know what would happen if, let's say, the originals were not to be found, but you had a copy that was scanned, if the court would actually accept that. I assume that you could probably argue that this is the only copy that's available, and they may have to accept that at some point, but there might be more to it than that. And then also, I've had this happen before where, relatives have asked me to be the executor, and so they send me copies of their will and their signed originals, and I keep those in my possession. So if you do that, you just want to make sure the executor is willing to take that responsibility to hold those documents as well. So, Pastor Bill, any other comments or suggestions?
I'm just, as a lay person, you're the professional, but as a lay person, I just find this just to be so overwhelming. But you have notes and things like that. Now, will you be putting those notes up onto your YouTube channel or?
Yeah, so what I'll do is in the description, and I'll post some comments on some of the summary notes that I have, so that those will be easily accessible as well for those that are listening. So because there's a lot to digest here, and you can go to the Aiken County, if you live in Aiken County, probate court website. There's not a lot there, but there is a list of what you need to have to start probate. And if you own a lot of real estate, or you own real estate in multiple states, it's probably wise to go ahead and do a revocable trust so that you can avoid probate in multiple states. And by the way, if you're domiciled in South Carolina, so domicile means you're a resident. So what does domicile mean? Well, the court would look at, whether you're spending time here in South Carolina, what kind of, things that you're doing to establish a residency, and you die in South Carolina, then you would be subject to probate in the county of your domicile or your residence. So if you have a vacation home in Hilton Head but live in Georgia, and Georgia is your home, you go to church in Georgia, you have cars registered in Georgia, you vote in Georgia, Georgia is your domicile, but South Carolina you have real estate, so you'd be subject to the probate court for the county that incorporates Hilton Head, unless you have a revocable trust, and then that could bypass that. So that's one reason why somebody might have a revocable trust, for example. But whatever county that you're domiciled in, that's going to be where your estate is administered ultimately.
Well, correct me if I'm wrong, but it sounds like if you have any more than just a normal debt, a revocable trust would be the way to go.
Yeah, absolutely. So I want to go ahead and ask you, maybe you could play that song that you were playing earlier. Pastor Bill puts together CDs. He writes original songs and then lets AI kind of put the music and lyrics together. And I thought it would be nice to have him take us out with one of his songs. So I'm going to say just before he does that I ask, Christ to bless those who have listened to the show, that they'll use wisdom and knowledge and do the right thing for their heirs, and set up a will, set up a way for them to inherit profit and property, and pass an inheritance to their heirs, and also to be able to write out all those things they need to do so that their heirs won't be, trying to figure out what their wishes were. And so until next week, I'll just say, manage yourselves and resources wisely, because we don't know the day or the hour when our Master will return, our Lord and Savior, Jesus Christ. So, Pastor Bill, let's go out with your song.
Somewhere deep in my spirit, way down low, I felt an emptiness within me. I felt so alone. Somewhere deep in my spirit, way down low, I heard the voice voice of a Savior calling me to come home. Some have said my hope was gone. I've been too bad, I've been so wrong. There ain't no way that He could ever change me. But on my knees I lifted my pleas and asked the Lord if He could please somehow, some way, change even me. Somehow deep in my spirit, way down low, way down low, way down, I felt His peace enter in me, and like a river it flows. Somehow deep in my spirit, way down, way down low, way down, I see the light of a city where I am longing to go. Someday I'm gonna see my Savior. What a day